Pete, are you guys ready?
Yes, ma'am.
Okay.
I thought so.
All right, good morning, and welcome to the City of St. Pete Beach Code Enforcement Special Magistrate hearing for June 10th, 2024. My name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. Before I begin, I just wanted to check. I believe there were some technical difficulties prior to the hearing, so if the city would like to address those, and we can determine how we're going to move forward.
Right. So I think I'm going to ask either Kristen or Pete to talk more specifically about the difficulty, but I think the plan is, since it's been advertised, we're opening it, and if we can get through any of the items, we will, but as Pete's about to tell us, there's limited, we have no access to certain files that we need to present.
Yes,
Okay.
good morning, Madam Special Magistrate Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. As you just heard, the difficulty is, although you've received the packet that was sent maybe, 10, 12 days ago, those packets, we're unable to access it because of limited access to Microsoft Outlook and everything else in the Microsoft suite. The only case we can probably hear is the request for another lien reduction.
Okay. And what about the 3 cases that we've got on the cases continued? Do we have any of those complied at all that we can kind of dispense with them?
One, I think we can hear, yes, and we can probably dispense with that. Do we have more than one?
Yes.
That we're able to comply without?
We can move through, I think we can move through our continued cases.
Okay.
Okay. Well, then let me go ahead and read my opening statement so that we can get that on the record for the cases that we are able to hear, and then we'll move through the 3 continued cases, and we will go from there. So I am a practicing attorney licensed by the Florida Bar, and I am board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today, and I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comment related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy, so please ensure that we have your current address or email address on file. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is to solely determine whether a city code has been violated, and under some circumstances to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline, if one is provided. If you wish to present any evidence today, please sign in before you speak at the podium, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, if you could please stand and raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
So sworn? Okay, so the first case that we should be able to address is 3A, case number 20240043, City of St. Pete Beach versus Thomas J. Dillon III.
Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. That is 422 86th Avenue. It was a 30-day extension to finish the landscaping plan, which he has. So the city will be just asking for $325 in administrative costs.
Okay, is Mr. Dillon here or anyone on behalf of Mr. Dillon here? Good morning, Mr. Dillon.
Good morning, Your Honor. I agree with what Mr. Cruz has said. Basically, we agreed. I've performed everything that the city had asked me to. And in the course of that performance, some additional part of the land was disturbed, and I've now fixed that and sent photographs to them. So I was in violation of the code section, I just didn't know it, and so I don't dispute the administrative fee. I'm willing to pay it, and I just confirmed no fines other than that.
Okay, perfect. Thank you, Mr. Dillon, and thank you so much for working with the city to come into compliance. So I will go ahead, and there will be no fines assessed with this case, but the $325 in administrative costs, and you will get an order to that effect.
Do I just pay that here?
You'll have to get with the city on how that will flesh out for you. Thank you. Okay, moving on to case number 202404141, City of St. Pete Beach versus Gintaris Corosas. I cannot get that right. I am so sorry.
Yes. Yes, Special Magistrate. Thank you. Good morning.
Mr. Cruz.
Lewis Cruz representing the City of St. Pete Beach Code Enforcement. This was a 30-day extension to have the van removed or registered. The property owner did have it removed, so the city will only be asking for $325 in administrative costs.
Okay. And is the respondent, Mr. Corosas, here? I know he was unable to travel the last time. Okay. I will go ahead and I will assess the $325 in administrative costs. I will not assess any fines or fees with this case as well, and have an order to that effect.
Thank you.
All right, and moving on to case number 20240029, City of St. Pete Beach versus Michael Martin.
Good morning, Madam Magistrate. Stephen Rivera on behalf of the City of St. Pete Beach. This was a status hearing for the cleanup of the bricks that were along the waterway. The property is compliant now. We're just looking for one-day violation, $250 plus $325 administrative costs.
Okay, any particular reason for the 1 day for the violation?
The notice of violation went out way beginning of the year. There was actually an amended notice of violation that went out. You know, we did what we had to do to notify them. We didn't hear back from them until we were here for the last hearing.
At the last hearing, okay. Anyone here on behalf of Mr. Martin? I know last time he retained counsel, or is Mr. Martin here? Have you spoken with him since last hearing?
He actually met us at the property. I did explain to him, you know, that we were going to do the one-day violation along with the administrative costs, but they are in compliance. He actually he went a little further beyond and cleaned up a little bit more than what we asked, so.
Okay, and because I believe the last time they had put evidence into the record, and then I had granted a continuance to a date certain. So for that purpose, I'm going to accept all the evidence that was submitted into the record at the last hearing. I am going to find that there is a violation for a single day. I will assess a $250 a day, or $250 fine for that day, as well as the $325 in administrative costs. And I will get the parties in order to that effect.
Thank you.
Okay, and because of the technical difficulties, I'm just going to assume we cannot hear the repeat violations or the new cases. Is that correct?
Yes, that's correct, ma'am. And
Okay.
so, based on what you just said, again, Pete Doerr, on behalf of the City of St. Pete Beach, based on what you just said, we will probably have to make an announcement.
Okay, but we can handle the lien reduction
We
case,
can.
correct? Okay.
So on the continuances, do we want to bring them back on July 8th? Is that what, right?
Yes.
Okay, so we'll bring all these cases back on the next meeting.
Next
Okay.
hearing.
So for purposes of the record, do you want me to read the case numbers into the record, or just a general overview? Because I will go ahead and get out orders on all of those to that effect.
I think we could say that all repeat violations and new cases listed on the agenda will be continued to July
8th, okay. So due to the technical difficulties, the agenda items 4A and then 5A through F will be continued to the July 8th, 2024 hearing at 10 a.m. Due to the technical difficulties of the city being unable to present the cases. And I will send orders of continuance out for that date certain, and we will reconvene on July 8th, 2024 to have those cases heard.
Thank you, Madam Special Magistrate. Like we discussed, we can hear the
The lien reduction matter.
lien reduction, and just so you are aware, can we go to the overhead, please?
Sorry, is it the national case number?
For the lien reduction?
Madam Special Magistrate.
Yes, the lien reduction, moving on to case number 20230541. City of St. Pete Beach versus Wilmington Savings Fund Society, FSB, trustee of Pretium Mortgage Acquisition Trust.
And
Mr. Dewar.
as you see on the overhead, there was an order granting a lien reduction request issued.
Correct. I remember Ms. McLean being here at the last hearing on this.
Yes, ma'am. And if you look at the overhead, you will see paragraph 7 that clearly says if respondent does not pay the full reduced lien amount to the city in accordance with this order, then such reduction is null and void, and the full amount of the lien shall be owed, including but not limited to all administrative costs imposed by the lien and any daily fines that would have accrued, but for execution of this order. So the city is requesting that that paragraph be honored and that the respondent be ordered to pay the full amount.
Okay, so then my understanding is that the reduced fine amount was not paid within the 30 days of the order that was presented. Is that correct?
Ma'am.
Okay.
Your Honor, if I could add to that, it's the city's position that we're without authority to change your order.
Correct.
Only you can modify or change your order. So the fact is that they came in late. We can't really do anything unless it's your order. So we have to abide by that unless you decide otherwise.
Okay. And so if you could please state your name for the record and your affiliation with the property owner?
Before the attorney gets up here.
Yes,
in
Mr. Dewey.
addition to what Mr. Dickman said, if you make a decision, we would like it to be documented in any future orders.
Of course.
Thank you.
Right.
Morning, Madam Special Magistrate. My name is Tyler Mesmer, attorney with Tapuzis and Associates,
Yes,
here on
Mr.
behalf of Wilmington Savings Fund. And to add to what the code enforcement officer said, this was the result of a calendaring error on the part of our firm, had nothing to do with our client. So what we did was to err on the side of caution. When we realized that the due date had been missed by 1 day, what we did was we did two things. We filed a second lien reduction request application, and then in paragraph 5, we made a two-part argument. May I approach?
You may please show it to the code officer first, or at least the city attorney.
This is what we filed. That's paragraph 5. That's a two-part argument explaining the basis for excusable neglect, and then the fact that even if this court did not, or if this body did not find excusable neglect, that it still didn't alter this body's 162.092B factors in reducing the fine in the first place. And while we appreciate
For the purposes of the record, if you could if you're going to make argument, the argument needs to be made.
She just wanted you to show it to us.
Right.
So I wanted to see what you're saying. So your arguments, you're gonna have to plead your case to the judge.
I have a copy of that for my packet. Thank you.
All right. So what happened here, and so we would. So what happened here was a classic case of excusable neglect. We had and have every intent to honor this body's order, the special magistrate's order. What happened was we miscalendared the day that it was due. So when it was 1 day late and we had it scheduled to go out for payment, we realized that the order said that it was due the day before. So we immediately filed a second lien reduction, and included in the paragraph 5 explanation is what I just showed everyone here. It's a two-part argument. The two-part argument is, one, the courts have consistently held, and it's become well established, that a calendaring error by a law firm is, quote, precisely what excusable neglect envisions. So excusable neglect here, we would respectfully submit, is a basis for allowing us to proceed with paying the reduced amount provided for by Your Honors, by the special magistrates. I don't know if I should call you Your Honor or Special Magistrate, whichever you prefer.
Either way is fine.
I'm used to saying Your Honor, but
That's fine, whatever you feel most comfortable with.
yeah, with Your Honor's April 11th order. And in fact, I have my checkbook with me today to pay that amount. We have every intention of paying that amount. We did have that. We did have every intention of paying that amount. The only reason we're here today is the gentleman who spoke before was not amenable to that. So we asked respectfully to have this hearing before this body. And the second part of our argument is that even if Your Honor was not amenable to the finding of excusable neglect, that our firm, with no involvement from our client, obviously, miscalendared the date that the payment was due under Your Honor's April 2024 order. It still didn't change the analysis, the three-part analysis that 162.092B, the three factors that are required to be considered when determining the appropriate fine. So with that in mind, and yes, while we appreciate what paragraph 7 said and what the gentleman before me cited, obviously, what we're saying is that a strict construction when payment was one due late as the result of a calendaring error would, with no involvement from our client, would violate the Cozell factors and would impose an undue hardship. Now, I would understand if a strict construction of that were imposed, where it were shown, and the gentleman before me showed that our client had every intent of violating the previous order, but it was our firm here, as shown by what I just showed you and you have in the file. It was simply our firm miscalendaring the payment, and it's a relatively small amount, and that's all we're asking to do. I mean, that's why I say it's simple. I mean, it's not like it's something we can't pay. It's not like something we can't pay today. So we're just asking to proceed with the April 11th order. And that's all I have. I mean, and if you have any questions though for me, I can answer them.
Rebuttal, Your Honor.
Yes, of course.
The reason this is here is because it's not that staff is amenable or not amenable. These are official orders from Your Honor, and I don't believe the city should be put in a position of being able to say 1 day late's fine, 2 day late is fine, 3 day nah. You know, that's just not going to work. So we believe that, I don't know that this is a frequent situation that happens or not. I certainly understand the law of excusable neglect. I get all that. I'm sure you do too. But I just want to make it clear that, you know, it's not the city that, you know, we believe these are your orders and we have to follow them. And that if, you know, if this were to become a commonplace occurrence, I think there does need to be some type of penalty for having, if somebody abuses the excusable neglect of defense. But I just want to make that clear that the burden shouldn't be on the city to have to say, I'm amenable to it, I'm not amenable to it. I mean, I think these orders were created in this forum, and they have to be either amended in this forum.
And just to be clear, I understand your position completely. The only reason I thought that this could be handled informally is because it was 1 day. We're not talking about excusable neglect that resulted in a 7-month delay or something like that, like some other case, some of the case law in the 2nd and 4th DCA have discussed. You know, like what would not fall within the ambit of excusable neglect. And I would say that this is clearly not going to be a routine with our firm. And if we came before you on another property that our client owned and this happened again, I would have every reason to expect that this would not this would not be tolerated. And so I agree with the person who spoke before me, that this could be noted in the record. We're only asking that because it was one day late, that.
Sure, and Mr. Mesmer, I don't think that the city is disagreeing with you. I think that the point that they were trying to make, and I don't want to put words in anyone's mouth, is just that, you know, it's an order. It has the gravity of law, and the city doesn't have the right or the ability, the authorization to negotiate around that law, whether it would just be one day an administrative thing. Because if they did it for them, you know, the city is bound by equal protection, making sure they treat everybody the same. If they did it for them, then they'd have to do it for everybody else, right? So coming back to me, I agree with your arguments. I'm happy to let you finish, but I tend to agree with you. So if you'd like to get with the remainder of what you had on the record, otherwise I'm prepared to make an order. I will say this just though for the record. I've had 3 attorneys now on behalf of your client come before me. There were misrepresentations made by the first attorney, which kind of put your client in this position in the first place. So I will say this, I have no problem with the excusable neglect law. I have no problem with your representations today, and I will go ahead and get an order out giving you've asked for 5 days in here. You said you have the ability to pay here today.
I can pay today, yeah.
Okay, so I'm going to give your client 3 days from the date of my order, which will be drafted and given to you today, to pay in full to retain the reduced lien amount. If it's not done within the 3 days, then it will go back to the full amount that will be required to be paid. So it will be 3 days from today's amount, or from today's date. I will get that order out to you, but I hope to not see you or anyone from your firm before me again in this type of a scenario, we've been through the ringer with a couple of you guys.
Oh, I understand completely, and the feeling's mutual. Not that you guys aren't fantastic. It's just a long drive up here from Miami.
I bet.
But I really do have my checkbook here with me today, so I can. Should I just pay the? I know you said.
Yeah, get with the city on how that's going to work, but the order will go out regardless, just
Okay.
as to tie a nice little bow on it and make it clean for the record.
Really appreciate it. Thank you.
Not a problem. And just for the record, also that this, you know, to Mr. Dickman's point, this is not in due course. This is not a regular thing that happens. So I appreciate your argument, and you know, it was made in good faith, and so this will be a one-off that we can kind of move forward with.
Yeah, and that, I mean, after the case is closed, I just wanted to get some direction from Your Honor about if this were to happen in the future, would you want us to handle this ex parte through your office, or? But I just do feel like there should be some official documentation of amending the order.
Right. I don't have a problem with it being ex parte if there's an agreement of the parties. But if there would be some sort of, you know, disagreement between the parties, no stipulation as to agreement for 3 days or 4 days, whatever, less administrative, more that kind of thing, then yes, we could probably bring it to a hearing. So for purposes of the future, if this were to ever happen again with you or anyone else, ex parte would be fine as long as the parties are agreeable.
Okay, very good. Thank you.
Thank you, Mr. Mesmer. Okay, and since that is all we are able to handle today, unless there's been some miraculous change in access to tech.
I don't think so.
Okay, so then the next hearing is scheduled for July 8th, 2024 at 10 a.m., and we will see you all there.
All right.
Thank you so much. Have a great day.